Well, hello everybody. Brian Horlick here. I want to welcome all of you who have taken time out of your day to join our AMA Ask Me Anything, our weekly live stream on everything to deal with condominiums. Everyone is welcome to tune in. Condominium managers, boards of directors, owners, residents, tenants, anybody connected with the condominium industry, government officials. We always welcome Doug Ford to our AMAs. I know he's watching, as our other luminaries. So thank you all for joining. As I've said before, why do we do what we do? We started the AMA, the weekly Ask Me Anything sessions, because in the condominium business, everybody speaks and deals with each other on a regular basis. When COVID-19 came to Ontario, uninvited, but definitely announced, everyone moved away from their ordinary business. People closed up their businesses. They started to work remotely from home. And all of the interaction between lawyers, auditors, managers, board members, residents, etc., fell by the wayside. Everybody was somehow remote and alone, like a bad marriage. And so we felt that this would be a way to connect everybody, and I think it's served its purpose and continues to serve its purpose, as we said before, from the many comments that we've gotten. Our hope is to continue the AMA Ask Me Anything sessions every Wednesday at 12 noon, even once COVID-19 leaves us, and we hope that it will be leaving us soon. However, like any guest that overstays its welcome, COVID-19 is reluctant to leave us, but it will one day. So, to recap here, we send out a COVID-19 FAQ bulletin every Tuesday. It's fully up to date. Everything in the COVID-19 bulletin is backed up with source material, footnotes from government sources. If you're not on our list, you should get on our list. You can click on our YouTube channel to get on our list. You can email us, we'll put you on the list, and you'll get the updated COVID-19 FAQ every week. In addition, as I said, we do this Ask Me Anything chat every Wednesday at 12 noon. We also have something called Case Law Corner, where we have our condominium lawyers do short 2-minute videos on relevant and up-to-date condominium case law, and that includes a brief written summary that goes out with the video. It's a great way to keep up-to-date and informed on condominium law, regardless of what you're doing in the industry. We also have something called Condo Spotlight, where we try to highlight a service or a supplier or contractor in the condominium industry, and we give them a platform to set out what they do and how they do it. We've done one Condo Spotlight so far, and that was on a cannabis dispute resolution center. So if you're having issues in your building regarding smoke and smells of cannabis, and you need to go to mediation, this is a dispute resolution center that can handle that. So, what do we have today in updates? COVID-19 updates. So as you know, we're all in stage 2. The entire province of Ontario, even Windsor, Essex, is now in stage 2, which allowed a lot of businesses to open. It allowed a lessening of the emergency restrictions, which was all good. Social gatherings up to 10 people are now allowed. The most interesting part of the updates is that the City of Toronto, along with other cities, have now passed a bylaw mandating face masks and face coverings, and we will get to that. Basically, a bylaw came out, passed now by the City of Toronto. This bylaw will be in force until the beginning of October. This bylaw sets out that every operator of an establishment that is open to the public shall adopt a policy to ensure that no member of the public is permitted entry to or otherwise remains within any enclosed space within the establishment unless the member of the public is wearing a mask or face covering which covers the mouth, the nose, and the chin. So this is now a bylaw passed City of Toronto and other cities where it is mandatory to wear a mask or a face covering in an enclosed public space. So there are exemptions to this bylaw. The exemptions are for children under 2 years of age. And for those of you that have children that are more than 2 years of age, I wish you good luck in having them put on and keep on their masks. Good luck to all mothers. Another exemption is if you have an underlying medical condition which inhibits your ability to wear a mask. If you can't put on the mask without assistance, that's another exemption. If you need an accommodation under the Human Rights Code and that accommodation is not to wear a mask, then that's another exemption. So other than those exemptions, everyone now who enters into an an enclosed public space must wear a face covering or a mask. The operator of the establishment is not required to ask for proof of an exemption. So if you walked into a enclosed public space and you weren't wearing a mask, you are obligated to wear the mask unless you are able to fit into an exemption. And if you tell the operator that you are exempt, they are not required to ask you for proof of that exemption. Okay, so in addition to all of this, you have to have a big sign in your space that says that all people who enter must wear a face covering or a mask. And there's a penalty. There's a fine if you do not comply with the bylaw. And the fine could likely be to the operator or to the person who's not wearing the mask. So how does this affect condos? Very good question, Brian, and thank you for asking that. It affects those condos that have a commercial component. It affects those condos that are commercial. So if you have a commercial condo and there are indoor public spaces in that commercial condo, so for example, a mall, a condominium, there are condominium malls out there, there are condominium offices out there, and they would be caught by the City of Toronto or whatever city they're in, this face covering / mask bylaw. So you'd have to wear masks in the open public spaces. Residential condominium corporations are not, by their nature, open public spaces, so the face covering / mask bylaw would not be relevant there, unless, of course, you have common areas where you cannot keep a social distance of at least 2 meters. Then it would be highly suggested that those condominium corporations institute a policy where face coverings / masks, are mandatory or highly suggested. Interesting question is, how does the bylaw affect condominium corporations that are residential but have a significant short-term rental component? Interesting. The bylaw sets out that it is applicable to common areas of hotels and other short-term rentals, such as lobbies, elevators, meeting rooms, or other common use facilities. So, if you have a residential condo with a significant short-term rental component, the question really is, do people have to wear a mask on the indoor common elements? And I'm going to suggest a resounding yes. Why would a short-term rental area, a condominium corporation that is quote-unquote residential but has a huge short-term rental component, why should they be exempt, really, from the face covering / mask rule when they are akin to a hotel. Akin to a hotel where people from all over the place are walking through the lobby and in the common areas. So that's what's happening with the mask bylaw. Very interesting. It's going to go till October. Now, if you've been up to date in other COVID matters, everything today is subject to the emergency order. The emergency order is supposed to expire, I believe it is July the 15th. However, there are ongoing discussions in the government to extend that to July the 24th. And as I said last time, and I'll say it again, COVID is not going anywhere quickly as much as we want it to go away quickly. And I think the government should just realize, or just be, to the point and say, look, it's not going away anytime soon. And these restrictions, although we're lessening them and trying to let people live and make a living too, we need to keep a lot of the orders in place. So, by extending it, for 2 weeks at a time and another 2 weeks at a time, I think it gives people a false sense of hope. I don't think it's really effective. But what I understand is that the government is trying to put an end to the emergency order, but at the same time, and before that emergency order is over, pass a new piece of legislation that will continue a lot of the restrictions that are in place today. So in other words, we won't have an emergency order with restrictions, but we'll have a new piece of legislation with restrictions. So you tell me what the difference is. I'm not quite sure. All right, moving on. We're going to start off with some questions from our audience. Marty Wagman. Our condo has extensive grounds. Owners have been setting up blankets and chairs and drinking alcohol. How wrong is this and what should we do? Cheers. Oops, not PC. So, with the reopening of the province slowly, now that we're in stage 2, a lot of the restrictions dealing with the outside common elements have been removed or lessened. I think that it's appropriate for owners to use the outside common elements. They are allowed to use common communal gardens. They're allowed to be sitting, on the benches. They're allowed to be playing tennis, providing it's not doubles, it's only singles. I don't see, why there would be an issue for sitting in chairs or setting up blankets. However, having said that, the most important thing is to maintain social distancing. So you have to have your at least 2 meters between people, social distancing, unless they're in the same household. Okay? So that would be your social distancing. Again, always hand washing, sanitization, very, very important. So you're allowed to do that. And again, maximum social groups of 10 people. So yes, you can have a blankets out there. You can have a social group of up to 10 people, as long as you have a very long blanket that will allow all those 10 people to have 2 meters between them. That would be appropriate. Now, next question. Paulette Forsyth. If a corporation wants to put in place rules or COVID restrictions, are they still required to circulate it for 30 days prior to becoming a rule? So Paulette, it's a very good question. I'm going to suggest that for COVID restrictions, I'm going to suggest that the boards put in place policies, not rules, but policies. Policies do not need to be formally put to the owners, as do rules. The problem with doing it by way of a rule is that, first of all, it has to go before the owners. The owners have the ability to requisition a meeting and to vote against that rule, which you may, as a condominium corporation, as a condominium manager, as a board of directors, you may want to take the position that no, This is so important to the health and safety of our community that we are not going to bring this forward to the owners, where owners and some owners have their own narrow interests at stake, and they're going to say, no, we don't want these restrictions. No, we're good. COVID is fine. It's not coming to our building. We don't need it. So you don't want to go down that road. You want to do what's right for your community. I would go forward with policies. And again, once COVID eventually disappears or becomes less, you are able to lessen the restrictions pursuant to your policy. So you may have a policy that you're going to prohibit something because of COVID-19, and then as the cases that are coming up in Ontario are less and less, you may say as a board, you know what, that policy that we have in place has worked very well, but I think we can now loosen up that policy. I'll give you an example here for short-term rentals. Sorry, not short-term rentals. Why is that on my mind today? In-suite renovations. Now, there was in the emergency order at a certain time, the province of Ontario said there's going to be a halt on construction. And that meant, of course, including in-suite renovations. And any in-suite renovations that were ongoing before that time were allowed under the order, and any after that time were not. But it was still open to every condominium corporation to pass rules or make policies that were more strict than what the government of Ontario was setting out. So for going back to in-suite renovations, today where construction is allowed because the emergency order has been lessened with respect to construction, there are a number of condominium corporations that are taking the position, and I say rightly so, that, hey, hold on one second. The Ontario government may have said that construction is okay, but the government, they never really think about us being condominium unit owners, living in multi-unit dwellings. And it's not appropriate for it to be open season in high-rise condos or townhouses where you've got all sorts of tradeswomen coming in and out all day long, renovating people's units. And if we are together trying to beat COVID-19, we must work in a sensible manner. And that means that whether or not the emergency order allows construction, condominium corporations, board members and managers have to manage the process. They can't have all sorts of tradespeople coming in, using the elevators, making noise when people are working at home. It has to be managed. And we have done for a number of condominium corporations, we have done in-suite renovation policies. And we set out specifically how in-suite renovations are going to work. And I think it's important to manage these things. And I think it's important to set it out in a policy in writing so everybody knows what the expectations are, and there are no contractors that come in are doing what they want to do. It's not appropriate, and any contractors who are not following the policy, they're told to leave the building immediately. So thanks, Paulette. Good question. I hope my answer wasn't too long. Marty Wagman, following up on gathering outside, can alcohol be consumed on our grounds? I think the issue of consuming alcohol or consuming any type of refreshments or libations, as they used to say, is really a condominium corporation rule matter. It's not really a COVID matter. If somebody wants to, sit on the grass on their blanket and have a glass of wine, that is something that would be dealt with in your normal rules. So I don't think personally that it's a COVID issue. It's what do you want? How do you want your common elements to be used by owners? And again, if you have rules in place for that, it's usually safety and security. Okay. Next question here. Jerry DiDonato. Can a board screen out applicants that wish to stand for election to be board of directors even though they meet the qualification criteria? So that's an interesting question. I wonder what the question is behind the question, but Under the Condominium Act, there are minimum qualifications to run for the board. Condominium corporations are allowed to amend or pass further bylaws, and in those bylaws you're allowed to put in qualifications, and you can set many qualifications in your operating bylaws for running for the board, such as we don't want people that are joint owners of a unit. We don't want a husband and a wife or a brother and sister to be both on the board at the same time. We want independent, separate parties. We don't want, other type of, financial people that have had financial issues or bankruptcies, whatever. There's a lot of things you can put in your operating bylaw for qualifications. And we suggest very strongly that board members or condo corporations put in proper qualifications. And I tell you, you need to do that now when everybody's getting along and the board is great, and you think, what do we have to do that for? We have great people on the board. You need to do that because one day you may not have great people on the board, and you may not like what you see when great people are not on the board. So I think it's very, very important to have proper qualifications and a good vetting of board members. But again, it's not for people, if a person qualifies to run for the board, it is improper, not appropriate, and there's no legislative basis for saying, well, you can't run for whatever reason. Okay? Next question. Alexandra, managing a huge building, working really hard. How are you this morning? Tuning in late. The masks are not mandatory in the common elements. Can we still enact a rule/policy to enforce wearing masks in the common elements? So rules have to be reasonable. The question is, would it be reasonable to mandate masks in the common elements? I think that there is an argument that it could be reasonable, subject to exemptions. But again, if you have to look at things on a case-by-case basis. The city, and a number of cities, are mandating the masks. You missed the beginning what we were talking about, the City of Toronto bylaw for face coverings and masks. And so the city has now mandated that for indoor public places. A condo is not an indoor public place, unless, as I said before, you've got a hotel attached to your condo, or you have a lot of short-term rentals that are allowed in the condo. Then it becomes, something where I think you should be mandating those masks. But for normal residential condo corporations, I think it's a good idea to encourage wearing masks in the common elements. I think it's a very good idea. I don't believe that you should mandate it unless there are areas in your condo corporation where the residents are closer to each other than the minimum requirement of 2 meters. So they got to be at least 6 feet apart. And in some condos today, the hallways are very, very small. I mean, who'd want to build a condo with a large hallway and waste space when you can sell more units? I guess we'll ask the developers that question. All right, next. Paulette, how practical is it to ask residents to clean and sanitize after using the barbecue? Is that sufficient, or must the corporation monitor? So, as we know, barbecues are allowed to be used on the common elements. This is part of the opening up of phase 2, the stage 2 opening up of Ontario. And, I think as part and parcel of opening up the common elements and opening up the barbecues, I think, it should be mandated as part of the obligation to use the barbecue. The person who uses it should clean it. I think it's probably unrealistic to have the concierge running out after every usage of the barbecue to ensure that it was washed down and cleaned. Now, if you have a lot of staff, you can do that. Or if you schedule the barbecue with sufficient time between usage, that you have your maintenance person do that. So I think it should be an owner responsibility. But if in your building you see or you feel it ain't going to happen, then I would suggest that you have one of the maintenance people do it and allow sufficient time between usage to have the barbecue cleaned up. just like you would do any other high-touch surface. Now, Murray Johnson, who has joined us today. Hello, Murray, and how are you? I want you to know, Murray, that you have been noted by your absence from our live stream in recent weeks. You've been noted. But it's good to see that you're here today, and I'll soon tell you why. Donald Bala, how are you? Melody Roche, it's hard to enforce. So it's hard to enforce, I guess, is that... I'm looking at the stream here, and I guess that would be the cleaning of the barbecue. So if it's hard to enforce, then it's got to be, I would suggest, your maintenance person. I know it's a headache, and it's a waste of resources, but unfortunately, this is what we have today with COVID-19, where if you just look at things other than the barbecue, you look at your elevator buttons, look at your doorknobs, your handles. There's a lot of cleaning going on high touch surfaces, and I think it should be for that as well. Next question, Melody, could the board mandate that security and superintendents wear masks at all times? What if the staff refuses? So, I think that the question really is not should the board mandate security in the super, but how do we protect the super and the security in the workplace from the issues of the COVID virus and the infections? So I think that it would be appropriate for security and superintendents to wear the masks in the public areas for themselves, and also, conversely, on behalf of the owners. Could you mandate it? I think that if you can only mandate what's in the law. You can only mandate what's in your policies. This is really an employer-employee issue, and depending whether these are independent contractors or employees, I'm suggesting that you could make reasonable policies affecting the employees. And so, depending upon the nature of the employment relationship, I think that's something that certainly could be considered. Then again, you have to look at exemptions and if they're able to perform their job functions with this, etc., etc. Now we're just going to stop for a moment, just while other questions are coming in. I just want to move on to fan mail, but keep your questions coming in because we're going back to all of these excellent questions. We had a piece of fan mail that came in from Jerry DiDonato, and he said the following: just a few words of thanks to you and the other HLD hosts of the HLD Lawyers Wednesday noon YouTube live presentation. Not only are these presentations informative, educational, and a pleasure to take part in, they provide a great comfort level to our board in managing our condo corporation, especially with the decision-making process. And there are more things that are set out here. It's such a wonderful fan mail that I'm probably getting embarrassed right now. But having said that, I'm going to put my embarrassment to the side for a moment. And I'm going to go to the last paragraph here where Jerry says, I've heard some participants periodically mentioned that you are a great saxophone player. Perhaps an interlude during one of your presentations may be a great time to show off your musical talents. So let me just say this, the periodical mentioning was all started by the well-known troublemaker, Murray Johnson. And I'm just going to say this. When I did the live stream last time, people were asking me, when are you going to do this saxophone thing? And I've put it off, and I said, well, one day I'll do it. And it was all because of Johnson. And Jerry DiDonato said, well, when are you going to do it? And what he did was he forced me to use the C word. And for all of you that have been in relationships before, the C word means commitment. And so I committed to do it today. So I hope you enjoy it. Here it comes. Okay, so for all of you, I want you to know that in addition to condominium law, I'm available for your weddings and bar mitzvahs. So call me anytime and we'll put together a group for you and have a good time. All right, back to the questions. Here we go. Aside from COVID, if an owner requests a kosher barbecue, as there is another barbecue used by all, if the board doesn't look in this request, could this be a human rights case? That is a really excellent question, and I'm going to suggest to you that this is an issue of religious accommodation, as is a elevator that is used on the Sabbath, and I would say that the board should make an accommodation for religious purposes when it comes to food, whether it's kosher food or halal food. So that's my comment there. Harold Stavis, message retracted. Okay, because he said he wanted to see some sacks today. Sorry, sacks. Bad slip. Donald Bala, good day, Brian. How can we enforce the rule for the mask if passed? Is it legal to enforce it? Can legal be effective? Can a legal letter be effective to enforce the rule? Brian, my apology for misspelling the error above. Okay, so the question is, can we enforce a rule for masks? And is it legal to enforce that rule? The thing is this. You have rules for safety and security, for health, safety, and security. The question is for rules, is the rule reasonable? For a rule to be valid, it has to be reasonable. And I'm going to say that if you go down the road of having a rule or a policy mandating the masks, I'm going to assure you that there will be people in the building that will absolutely refuse to wear the mask. There will be people in the building that will tell you that COVID is just a flu, and in fact it's just a rumor. It doesn't exist. So I'm going to say, I would take the position that the City of Toronto is taking. I would take the position that the Province of Ontario is taking, that we need to educate people and we need to try to encourage them to wear the masks. Where it becomes an issue that you must wear the mask is if you are in a condominium in a common element area and you cannot have a social distance of less than 2 meters. There I say it would be mandatory. Otherwise I would say it's highly encouraged. And again, going along this road, there are other condos that are considering taking people's temperature remotely, guests or visitors or contractors when they come in the building. So that's something else. If we didn't have enough on our plate to think about, that's something else as well. Alexandra, awesome. Paulette Forsyth, I agree, awesome. Melody Roche, great skills on the sax, haha. Are boards allowed to continue to keep amenities, which are now permitted, open, closed? I get that they can go above and beyond government recommendations, but can they just? So the question is, are boards allowed to continue to keep amenities closed, which are now permitted to be open? And I'm going to say again that condominium corporations can have policies, they can have rules that are stricter than what the government emergency orders set out. So if the government emergency order or the stage 2 now says, for example, tennis courts, you can play tennis, only singles. Or even a better example being an enclosed, an inside amenity, where you can, for example, not a fitness area, because those still must remain closed, not a sauna, not a whirlpool, that all has to remain closed. But if it's, for example, a card room where people would maintain a social distance of 6 feet with sanitization and extra cleaning, etc., hand washing, the question is, could you close that? I'm going to say you could. Whether that would be appropriate to close, you'd have to have really a good reason for that, because again, the policies have to be reasonable, the rules have to be reasonable, and I don't think there's a one size fits all answer. I think it depends on your building, the setup of your amenities, and the makeup of your population. So for example, if you have a very senior population in your condominium community, you may say, well, look, the seniors are very vulnerable for this type of thing, and maybe we should keep our card room closed, for example. And I think that, properly thought out, I feel that you could do that. Next. Murray Johnson, the troublemaker. I'm much happier now. Bravo. Haha. Melody Roche, shut it down indefinitely. Is it fair? No, it's not fair to shut down an amenity indefinitely. You should, if you want to shut down an amenity, it has to be for really a proper, valid reason, a proper purpose, based on your community, based on the physical setup of your amenities. If you need to, everything has to be done, thinking it through properly. And so, can furniture be moved around? Can times of usage be staggered? Can appointments be made to use certain amenities? All these things are considerations that can assist in making the decision between black and white, it's open or closed. Yes, maybe it's not closed, but it's open with certain restrictions, and maybe that is the best answer. Jerry DiDonato, another known troublemaker. Extremely impressive, thank you. You can play at my weddings and bar mitzvahs at any time. What is your hourly rate? Everybody's asking lawyers today what their hourly rate is, but I'll do it for you at a fixed fee for your son's wedding. I'll do it at a fixed fee. How's that? All right. Michelle, the health inspector is telling us that the maximum number of people that can be in the entire pool enclosure area is 25% of our posted maximum number of people, which is 100. So we are supposed to have not more than 2.5 people in the entire pool enclosure at the same time. In previous years, it was our understanding that this number, 10, applies to the area within the white lines that are painted around the pool and do not apply to the entire sitting pool area by the pool. Apparently, different pool inspectors have different interpretations of the pool reopening rule. Where can we get a proper guidance from? By the way, we have a huge pool with a huge sitting area. We have arranged a lot of space in between users. So the thing is, the various municipalities have put out brochures, soft copy brochures that you can download from the net on opening up your pool, and a lot of the rules and regulations are in there. So I'm going to suggest that you download that. I know that in the FAQ that we sent out on Tuesday for the City of Toronto, we have put in a link on pool openings and the steps that you need to take. So, there's a lot of information out there, and there's a lot of misinformation out there, but depending upon where your condo corporation is located, I'm going to suggest that, you take a look at the available documentation that they have on the internet. Click it, and you should have all of your answers there. But it sounds like the health inspector may not have been fully apprised of the most recent legislation. Murray Johnson, I would contact your pool service provider, and they should have the answers we need. There's another fine suggestion from Murray Johnson. Murray, anything else today? Because I'm looking for great suggestions. And I know you've got a few more in the bag, so let's hear what they are. All right. Next question from Melody. What can managers do about complaints from one owner about another owner with regards to COVID-19? Initially, when people were returning from overseas, other residents would watch them and keep track of them. So people that were returning from overseas should have been in quarantine for 14 days. I think it would be appropriate for a resident to discuss or to mention to management that, so-and-so who just came back from whatever country is not following quarantine protocol, and I would, as a manager, I would call the health department and I would lodge a complaint, and I would have them take care of this. In addition to providing a communication to the owner, maybe I would do that first to the resident, and advising them that they have to be in quarantine. I've seen those letters before coming from condominium management. But if that's not going to be sufficient, I would definitely call the health department and maybe involve legal counsel, because it's not correct for people to flout the laws and not go into self-isolation and quarantine. As I said before, everybody is in this together. It's not a time to be selfish and greedy. There was an argument with an owner not respecting the 2 people per elevator limit. Well, I think it's important, if you have a limit of 2 people, I think it's important that people respect that. And I really think very strongly that if they're not going to respect it, they need to get an immediate letter from management. They need to get a letter thereafter from the condominium solicitor. I would put in a call to the health department, and I wouldn't allow, as best as possible, such behavior. It's really uncalled for. So I will tell you that along with the very many pieces of information out there, CMRAO, which is the Condominium Management Regulatory Authority of Ontario, has a pamphlet, soft copy, that anybody can go to their website and download. It's called Reopening Ontario After COVID-19, a guide for condo managers, and I've reviewed it, and it's quite good. And it talks about a number of things. It specifically speaks about, should you be holding meetings, AGMs, owner meetings, and if you should, how. And it discusses the ability to move forward with electronic voting and virtual meetings, which condo corporations need to consider. It's been my view that people should wait and see what's happening with COVID-19 and the number of people that can be in an in-person meeting. My suggestion was to wait till the fall, till September. But I'm seeing now that a number of condo corporations whose AGM was supposed to have happened already are moving forward with electronic virtual meetings. So that's started to happen, I guess, in July. There was maybe a bit in June, but they're really starting to come along now in July and August, and people seem to be moving in that way. As you all know, that the emergency order amended the Condominium Act, and so AGMs who are mandated to have, condo corporations who are mandated to have AGMs within 6 months of the end of their financial year, that period has been extended so that AGMs are required within 90 days of the end of the emergency order. But people, some boards are saying, well, when is this emergency order going to be over? So, they're starting to move forward with electronic meetings. Having said that, again, the government is going to extend the emergency order to July the 24th, and they're presently contemplating a bill which will allow for restrictions to continue even at the same time as they're rescinding the emergency order. So it looks to me that the emergency order will be rescinded, but before it's rescinded, there'll be another piece of legislation that's passed which will allow the restrictions to continue. Getting back to the CMRAO pamphlet, it also discusses for condo managers protocols for entering owners' units and protocols for use of the common elements. So it's quite a good brochure. I suggest that any condo manager, board member, resident can take a look at this. It's all good information. Interesting, they have some statistics here. One of which was, does it appear that condominiums are having significant difficulties collecting fees from owners. If you recall, when the pandemic first came to our lovely country, there was a whole outcry that owners would not be able to pay their maintenance fees and condos wouldn't be able to pay their bills, and everything was going to be terrible and the world was going to go upside down. Well, now we see that 72% of the people, of the managers who responded to the survey, have indicated that they have not observed any difference compared to before the emergency orders were in place with respect to collecting condominium maintenance fees. And 27% of the managers said that they believe there's been a slight increase in the number of owners who have defaulted in the payments. So not all doom and gloom. Another interesting note here from this survey was that 40% of the managers indicated that some of the clients were taking advantage of virtual meetings, and 21% said that no more than half of their clients would be taking advantage of this, and 40% said their clients are not taking advantage of this. So it's a good thing. It's a good piece of reading. I suggest that if you have some time and you want further information, that you take a look at that. And again, going back to the stage 2, outdoor fitness equipment is still taboo. You can't have outdoor fitness equipment being used during the stage 2 at the moment. Indoor and outdoor pools, of course, can be used. Shower facilities, ancillary to the pool, and changing areas can be used on the condition that you have your minimum space of 2 meters and it's sanitized properly, and don't forget your hand washing. But saunas and whirlpools and that type of thing are still taboo. Now, next question here. What can managers do about complaints? No, we did that one already. All right. The CMRA booklet. Yeah. The CMRA booklet also suggests that managers should prepare a safe reopening plan. I think it needs to be the entire governance team, even include some site full-time staff in the discussion. So yes, the CMRA booklet talks about reopening. And this is something that needs to be addressed by the board, and needs to have the condo manager, site admin, all involved in the process, because everybody is working here together on the same team and we want things to go as good as possible. Armin Hoxha, would it be wise to send out a survey to the owners regarding the way an AGM will be held, or when? So I'm thinking this. What you need is to have an AGM. That's what you need. And the question becomes, how will you do that? In what format will you do that? You have today a cap on a social setting of 10 people. So an in-person meeting right now, you're not going to have it. So it's either a meeting by proxies, all paper, you can have that today, or it's going to be a combination of paper and virtual meeting, and you can have that today, or it's going to be just a virtual meeting. So I don't think a survey is going to help you. However, you need to look at the demographics of your building. And if you have a population that is more, let's say, computer savvy and they don't have an issue with technology, then you can have a virtual meeting and a paper meeting. So you'd have proxies and electronic voting. Proxies for people that are not good with technology, and electronic voting for people that are good. Because if you have a population that is not good with technology, what would be the point of having a virtual meeting when you couldn't even get a quorum, because people either aren't computer literate or can't use the computer for anything other than reading the news. So you need to look at your demographics, and I think it's the board and the manager together that should make that decision. Next question here. Murray Johnson, no survey for the AGM. The board is empowered to make these types of decisions. Okay, well, I agree there. It's the board. Sit down with the manager, figure out your community, and move forward in the best way possible. And your answer may be that we're not able to have an AGM at this point in time because our demographics won't go for it. They don't know how to use the computer properly. But then go with a paper proxy if you must have the AGM. And other people may say, you know what? Or other boards may say, you know, there's no rush here. Nobody runs for our boards anyways. We'll just have it in 90 days after the emergency order is over. But keep in mind, we don't know when that's going to be. So, Armin Hoxha, so he asked a question about, how to have the AGMs, and he's now saying that almost half of his building has no computers. So there's going to be, for you, Armand Hoxha, there's going to be definitely a challenge to get quorum at your building. And I'm probably going to suggest that you're either going to do a paper meeting, proxies only, which is probably what will happen over there, or you're going to wait till the emergency order is over and, then move forward with the meeting. But even when it's over, I'm sure that you're still going to have restrictions on the number of people in the social setting, because there's no way that we're going to go from a maximum of 10 people in the social setting to, yeah, sure, let's have 200 people tomorrow at our AGM. It's not going to happen. So I think in your situation, it's going to be a paper proxy. Okay, so we're just about out of time here. I want to thank everybody for coming out to the live stream. As I said before, we do this every Wednesday at noon, and you can see Mr. Chaplick next week, Bradley and I. Bradley Chaplick's one of our senior associates, and he hosts every second week, and I host every other week. So between the two of us, we've got you covered. Don't forget this Friday to look forward to your condo case law corner video that's going to come out on a new case, and I think that's going to be good reading for everybody. And once again, every Tuesday, look forward to our COVID-19 FAQ, which will give you all of the most up-to-date information. Julia Laurier, she wants to have an encore on this saxophone concert. Well, Julia, if you missed it, I'm sorry. You're going to have to go and see it on video, and I will be getting a royalty for every click. All right. I think we're done. If there's any other... One last comment here is 2 comments. Murray Johnson, always much appreciated. Thanks for the valuable service. Harlan Stavis, what instrument does Bradley play? I'm not going to even answer that. You'll have to ask him that yourself. Again, thank you very much for coming and listening and spending your time with us. We'll see you next week. Bye-bye.